Uh, okay, then we can begin. It's 9:40. So, just to make sure that everyone's in the right room, this session is on the California new cyber audit regulations. Before we begin, let's introduce ourselves. So, I'm Paul Lanois. I am a director at the European law firm Fielding Fisher. I advise clients in relation to data protection, privacy, and cybersecurity law. And I also teach privacy compliance at the University of California Law in San Francisco. Before working at Fielding Fisher and teaching at the university, I was working internationally. I was with Credit Suisse. I was VP and the senior legal counsel at Credit Suisse at their office in Hong Kong, and also was working at Credit Suisse in the headquarters in Switzerland. Yeah, so that's about it from me. And then Nandita, do you want to introduce yourself?
Sure. Hi everyone, I'm Nandita Rao Narla. I head the Technical Privacy and Governance program at DoorDash. Prior to DoorDash, I had my own privacy tech startup and spent a number of years at EY. So very familiar with audits, moved from a security engineering background to a privacy engineering background. So interested to talk about the upcoming regulations. I'm also part of several standards bodies, think tanks related to privacy. So if anybody's interested in participating in those, please meet me after this session.
Yeah, likewise as well. So I'll be handling the legal aspects. If you want to talk about the legal aspects as well, feel free to come and reach out to me. And I guess if you don't have the time today, feel free, of course, to reach out to us outside of the conference. If you're shy today, we're available. You can reach out to us on LinkedIn or whatever platform which if you're more comfortable with. Okay, then so let's begin. And as usual, we have to have this standard disclaimer, right? We're giving our own opinions on things. Those do not necessarily reflect the views of our employers and so forth. I guess it's especially for those in-house. And so we'll be talking about the cybersecurity audit regulations from California, and we're going to be looking at it into two parts. So I'll be handling the first part in relation to the theory. What are the requirements? What do the authorities expect? How has it been enforced? How have cybersecurity requirements been enforced by authorities in the past? And so forth. And then part two from Nandita, she'll be looking more into the in how you're going to be implementing that in practice. What are the objectives? How you should scope it? What is the time frame? How you should actually proceed to do that? The audit checklist and so forth. But before we actually begin, maybe it might be interesting, if you could, by a show of hands, tell us, well, how many of you are privacy professionals? Okay, so we have some privacy professionals in the room. What about auditors? How many of you are auditors? Okay, so we definitely have more auditors in the room, and that's fine. There is no prerequisite for the session, so we're going to look at it and try to demystify as well the requirements.
I'll step down so that you can.
No, I mean, no, I was just checking whether you had anything else you wanted to jump in.
I'll let you go over the theory and then I'll come back up for practice.
Yeah, sounds fine. So what are we going to be talking about today? So we have this California law, which you may have heard about, the CCPA, the California Consumer Privacy Act, which has already entered into effect. So the authorities are enforcing it. There have been some enforcement action as well, which were taken. And what happens is that in the text of the law, it does mention that the law gives the power to the California Privacy Protection Agency to issue regulations in relation to cybersecurity audit requirements. The law says that those regulations will come out and those regulations would then provide details as to what the authorities expect organizations to do in terms of the audit, the scope and so forth, what are the requirements, and also what organizations are expected to do. So the regulations haven't yet been formally issued, but then what happens is that we have draft regulations which have already been issued by the California Privacy Protection Agency. So those are just draft. It doesn't mean you have to quickly rush after the session and quickly implement them. But then what the draft regulations means is that the authorities are already telling us, well, this is what they would like organizations to do. They are still going through the process of rulemaking. They're still going through public comments and so forth. So it's possible that, and actually very likely that the regulations may change from now till the final version. There are still some placeholders as well in the text of the regulation, so it does indicate that the authorities are still thinking about certain things. But then, because they've provided us with this draft, it does mean that what I was saying that you shouldn't rush after the session to quickly implement the regulation. It does mean that you have to soon start thinking about it, thinking about what you should do and so forth, so that once those regulations are in place, you have this, you're not caught by surprise. An important point to bear in mind as well is that we have this decision from a California Court of Appeal back in February, and then it was confirmed as well by the California Supreme Court last month. The fact that decisions, regulations from the California Privacy Protection Agency are applicable, immediately as and when they are finalized. There is no transition period anymore. What happened was that in relation to other previous regulations issued by the California Privacy Protection Agency, there was litigation, and some organizations was thinking, well, it's not fair for regulations to be applicable immediately. There should be a one-year transition period. But then, ultimately, the courts decided otherwise. They've now agreed that there is no longer any transition period. So it does mean that whenever the regulations become finalized, the time for compliance would begin at a time. You won't have a 1 year or whatever to comply. So that means that you have to really start thinking about compliance really soon. Get your budget in order as well, the resources and so forth. So who is impacted by those regulations? Well, not all organizations not all organizations are impacted. They do target only organizations of a certain size. So you can see here on the slide that there is this flow chart that you can use in order to assess whether your organization may be caught or not. So again, this is based on the draft regulations. It may still be subject to change, but then we do think that it's very likely that they're going to keep this as it is. So it does mean that if you are a large organization, for example, if your annual revenue is mostly derived from the selling or sharing of personal information, well, you will very likely be caught by the cybersecurity audit regulations. If you are processing the personal information of more than 250,000 consumers or household, you would also very likely be caught. Are you processing sensitive personal information? For example, are you processing, credit card information? Are you processing, driver's license ID? Are you processing, other types of information which is defined as sensitive personal information under the text of the law? Well, in that case, you're likely captured as well. And if you are processing information of children as well, more than 50,000 children under the age of 16, then you will likely be caught by the law. So it does mean that quite a number of organizations are going to fall within the scope of the law. And some of you may be thinking, well, that's nice, but then my organization is not actually headquartered in California, so do I really need to worry about it? And the thing is, well, it depends. Even if you don't have any brick and mortar office in California? Are you doing business in California? Do you provide products and services to California consumers? And that's the criteria actually that is used by the authorities. They're looking at, well, how many California residents are going to be, how many California residents are you servicing? So the numbers which are on the slide here, when we talk about 250,000 consumers or household, that actually means California consumers, not a worldwide number. But then if you do provide products or services to a large number of California residents, as per the slide that you can see here, well, it does mean that you will be captured by the CCPA and by the regulations, even though you may not necessarily have a physical presence in California. So always remember, and that's also on the slide deck as well, always remember that you do not need to be physically based in California to be captured and to be subject to the requirements of the CCPA and the regulations. Now, some of you may be thinking, well, what actually makes those audit regulations special? Because we had GDPR, we had CCPA, we have lots of other laws in relation to privacy and which touch upon security as well. So why do we need to worry about those regulations? Well, those regulations are quite unique in my view because it does go beyond the text of other privacy or security laws. If we look at the GDPR, for example, the GDPR simply required organizations to implement appropriate technical and organizational measures in relation to security. And lots of folks have always been asking, well, what is appropriate for my organization? Why can't the authorities just give us a list of security measures and then we can just follow the list? Well, the reason why they haven't done that is that they want to make sure that the law doesn't have to be updated every couple of months or years, as technology progresses, as security changes and so forth. And also because it depends on the size of the organization. If you're a large organization, you're going to be more attractive to hackers, and therefore you will need to have higher security measures as opposed to a startup with only 5 employees, for example. So there's that. The type of data that you are handling and so forth is also going to come into consideration and so forth. So that's why authorities have always been reluctant to set a list of security measures. And if you look at the text of the current CCPA, the text of the law, well, it doesn't as well specify specific security measures. They simply say you need to implement reasonable security procedures. And what is reasonable? If you ask 10 people in a room, what is reasonable, I'm sure you're going to get different answers as well. So you do have this question mark in the past in relation to what actually is required. But then now with the CCPA cybersecurity audit regulations, well, you do have a list of specific cybersecurity components that they expect an organization to have in their cybersecurity program, and they are extremely specific. They list 18 specific components. You have quite a number of specific areas like encryption, zero trust architecture, access controls, and so forth that the authorities expect you to have in place. And what is important as well is that you have to do an annual audit in relation to those 18 security components. And not only do you have to do the audit, you can't just keep the audit report in a drawer, somewhere and bury it. They actually tell you that you actually have to provide an annual notice of compliance to the authorities. You have to file that annually as well. So, in the past, when authorities have been looking at cybersecurity, they have always been, going after companies, and they have, as you can see on the slide deck here, they have been, telling organizations, well, you didn't implement reasonable security measures. I mentioned some here. I'm not going to, to go through those specific examples on this slide deck. Here, but then they've always told organizations, well, you have to have reasonable security measures. And if we take the example of Equifax, and you probably heard of this company called Equifax, I'm sure, and it made the headlines as well. There was this huge data breach which took place, and then it turned out that it was the organization did not necessarily patch the vulnerabilities, even though there was a patch available, and then it made the news, and you had quite a few executives who also had personal liability, in the sense that you have this chief information security officer who was who had to leave. You had the CEO as well who was who had to leave as well, and it does show as well how security is important, how it is being followed as well in the news. Now, we're not going to name and shame companies, and that's not at all the purpose of the presentation. The reason why we mention and call out certain companies is because, well, they're good case studies, and I'm sure that they had their own reasons why they didn't comply with those security requirements. Maybe they had budgeting issues and so forth, or other considerations. But then it's interesting to look at it because we don't want to repeat those mistakes. So when the Equifax breach was discovered, well, what was interesting is that the authorities, the feds, the FTC, they have announced as well, that yes, they are investigating. That was quite new actually at the time, because it's not always that the authorities announce that they're beginning an investigation on cybersecurity. It's quite a rare occurrence, but then that was one of the rare times where it happens, and it's likely to happen again in the future. And it did result in a big payment, $575 million payment settlement as well. So it does mean that, it's something to be mindful of. Ring as well is another big example where the company was found by the FTC to have illegally surveyed consumers. There were issues surrounding security, the fact that according to the authorities, there were not enough access controls in place, that some employees could access data of the cameras, and that was in abusive by the FTC, and that led to again another big penalty, $5.8 million dollars imposed against the company. So what we have from those takeaway, the takeaway from those enforcement actions is that the authorities, they do look at certain security measures, and they have, even though you don't have a formal list as to what is required and so forth, we can deduce from the different enforcement actions that there are certain security measures which are deemed absolutely necessary, and if you don't have them, then you don't have reasonable security in place. And you have on the list, you have on this slide deck, you have a different list of items which are essential, and no organization should go about having in place, of course, an information security policy that is written. You need to have in place as well, access controls, what are the protection against password and so forth, training, and I think that those security measures, are fairly basic, and but then it's always good to remind everyone of those basic security measures, because if you don't have those, the authorities are going to say that, well, you don't have in place reasonable security measures. And then you do have as well, some other authorities. For example, you have this case, the CFPB versus ACI, which did also mention that reasonable security means the adoption and enforcement of information security policies and human and technical internal control measures that are technically substantiated by the latest knowledge widely held by the information security research community, and that are documented in human readable format by internal corporate threat modeling documents and so forth, and sufficient to defend and ensure the confidentiality, integrity, and availability of sensitive consumer financial information. So in this case, it was relating to a financial institution, and what was important as well is that what the authorities looked at as well, what is reasonable. We have to look at what is widely held within the information security research community. So it is quite a broad, a vague concept. Again, it does demonstrate how things are changing because, like I mentioned, now with the new California cybersecurity audit regulations, you do actually have a list of different criteria that organizations are expected to abide with. Yep. So now I'm going to hand it over to Nandita, who's going to be talking about the readiness timelines.
Thanks, Paul. So Paul spoke about the theory of how enforcement action has been done, this vague terms of reasonable security measures or appropriate technical controls. Some of that is not relevant now for the CCPA audits because there is somewhat definition on what these expectations are. So if you're looking at the timelines, understanding that this regulation is still in draft, in December the draft was published, but in previous meetings there has been a strong indication that likely in July it's going to be formalized. It may have certain changes that happen between now and July, but the general talk is that it's going to be formalized and effective in July. So let's assume that that's that's the date when it becomes effective. So from then on you have 2 years. So these 2 years have to include 1 year of actually doing the audit and submitting those compliance report to the agency. So pretty much you have 1 year for a readiness assessment, getting things buttoned up, and 1 year for actually doing the audit. So that's the timelines that you can work with and make sure that you have teams, resources, and priorities aligned. One more thing I wanted to make a note is that there are no gaps allowed in between these successive audits. So it has to make sure that whatever timeline you set, that's what you have to follow going forward. What are the objectives for these CCPA cyber audits? So 3 objectives. The first one is protecting consumer personal information. This is focused on confidentiality and integrity, with basically making sure that the personal information is protected from unauthorized access, destruction, use, modification, and disclosures. Pretty standard stuff here from a security perspective. The second one is also focused on security, where the program needs to protect data from loss of availability. So this is where we're covering the availability aspect of data protection. The third one is for the privacy folks in the room, focuses on negative impacts to consumers. So this is where the objective is to make sure that end users, the consumers, are not harmed. So there is that if there is a breach or if there is a loss of personal information, that they are not impacted by economic, physical, psychological, or reputational harms. So so that follows the standard Soloff taxonomy of harms. In terms of how will you scope these cybersecurity audits, the good thing is there is very broad discretion on how you determine scope and what is required as part of the audit. So because there's a lot of verbiage around in this draft regulation as well, there's a lot of verbiage around as appropriate and taking into account several factors. They mentioned 6 specific factors, like Paul mentioned before. The business size, if you're a startup, you can have more leeway versus if you're a large company. How complex is your business? What types of processing activity are you doing? Are you selling customer data? Are you handling very sensitive information? Do you have race, gender, genomic data? What is the scope of business process activities? Which regions are you operating in? Like we mentioned before, you don't have to be incorporated or physically be present in California, but if there are certain types of the business that are not being performed in California, you can exclude those. State of the art and cost of implementation of these controls is definitely a factor. State of the art is something that if you're not familiar with, I just have a diagram on the right here which explains how state of the art is defined. It's defined as the best performance available in the market to achieve an IT security objective. So keywords here, available in the market. It has to be available, no research related controls, or if there's something that's still in development that's not considered state of the art. And state of the art is generally considered around two axes. Is it recognized? For example, complex passwords, pretty recognized and have been proven in practice. 2FA controls, standard encryption, like these are things which we would call state of the art because they are in practice adopted. There are products that are easily available. Checklist. We've been talking about these 18 areas for a little while, and on the right you will see those 18 areas. Very standard stuff. There are no, I don't see any shocking elements in here. They're very standard cybersecurity program components. One data point that I did want to mention is like this is the first time I've seen in a regulatory draft requirement that it says zero trust architecture. So that seemed a little bit surprising to me, but others is like very standard stuff. These are the 18 areas that need to be included in the annual audit scope. If one of these or more than one of these are not present or are not implemented in your organization, you'll have to define what are the compensating controls. So let's take an example. So for encryption, let's say you don't have encryption in place. What are some of the compensating controls that you can talk about? Audience question. No encryption. Sure. That's a good one. Tokenization. So if there's no encryption, tokenization a variant. Any other example? You can potentially say, one of the answers is pseudonymization or like de-identification. You can say that that does reduce risk, but maybe not completely, so you may need additional compensating controls. Anybody else has other compensating controls for encryption? Any other access controls or data minimization related controls. So you'll have to indicate that you have other compensating controls implemented. Second, you'll have to justify and provide a business reasoning that why is encryption or X control not necessary for protection of personal information, and how you're achieving equivalent security with these other controls. So that justification would need to be drafted. Anyone has questions on this? Yep.
Are there very, these are very generic terms, right?
Yeah.
Do they have very defined control sets like, encryption at rest, encryption in transit, encryption in use, and then the level of encryption as well?
No.
Right? Cloud level versus disk level versus, there's all types of encryption. So
Good question. So the question was, how descriptive are these 18 areas? Are there underlying control level requirements in the law? And the answer is no. They are pretty high level, and you may have a little bit more context if you read the regulation, maybe like a few bullet points, but it won't go into that level of detail on specific controls or specific encryption type.
And then a follow-up question. So with these controls, I'm assuming this is like, is it your holding mark, or is just the, like, can you scope it kind of like how you do SOX, where this is really just around the your system that's
Yes.
privacy?
There is very broad discretion on how you scope these audits. First is that this audit is focused on customer information, customer personal information. So wherever there is customer personal information, specifically like California specific customer personal information, that would be in scope. Most companies don't separate between state, so you may end up in a situation where pretty much everything that has PII or like how it's defined is covered. Okay. Moving on to more guidance on what does that audit look like. Let's focus on the auditor requirement. The auditor needs to have, it needs to be objective and independent. What that means is if you are building the program or if you are part of recommendations, providing recommendations or any way part of implementation of these controls, you cannot be part of the audit. You cannot be the auditor. So this is a very important distinction. So like security and privacy teams or security assurance teams cannot do these self-assessments if they are already involved in control implementation, guidance, reviews. But you may be able to use internal audit as long as they can demonstrate independence. You are required to retain all information for 5 years. Even if you're not submitting everything to the agency, you may be asked to produce it. So general, like all audits, evidence audit didn't happen. You have to retain all the evidence for a period of 5 years. Other audit execution requirements. You have to make sure that you are assessing control effectiveness for all of those 18 components. These are not process, these are not like walkthrough or like process type audits. These are control audits. You'll need to identify gaps and weaknesses, document what the plans are for remediation, as well as if there were any corrections to the previous audit that was submitted, make sure you include those in every year's successive audits. The scary part is in the green box there, that these audit reports, you'll need to report them to the highest level, so that's directly to the business's board of directors or governing body, and if there is no such body, then you have to report it to the highest ranking executive who's responsible for the cybersecurity program. This report also needs to be signed by a member of the board or the governing body, whether to attest for a written certification of compliance or an acknowledgement of non-compliance and be submitted to the agency annually. Okay, let's move into how will we, so assuming this becomes effective July or let's say any other date, what does that readiness program look like? What can you do day one as soon as you come to know about this cybersecurity audit regulation being effective? First, planning. Make sure you have the right stakeholders involved. Ensure legal, security, privacy, IT teams, business teams are involved in defining how this audit is scoped. That's a very crucial part and will set the stage on how you do successive audits later on. Review whatever program documentation on the security program that you have and assess the posture in general at high level to assess what are the areas that you want to focus on for the readiness assessment. If you have some sort of cybersecurity audit that you already do, that's amazing. All you need to do is then do a gap assessment against those audits. So if you're doing a SOC 2 security audit every year, if there's a third party that does it, make sure that you review the scope of those audit against these CCPA audit requirements and understand if there is any gaps, then make sure you fix those gaps as part of this readiness assessment. If everything is covered, then you're good to go. You just have to focus on how this will be reported and go through an assessment of making sure that the leadership is aware of this upcoming regulation and that there will be a minimal impact. But if you have nothing in place, if there is no other audit being done, this might introduce a significant compliance burden, and you will need to make sure that there is staffing and budgets in place to be able to do this on a recurring basis, especially if there are control deficiencies that need to be fixed before those successive audits can be done. Okay. Like I mentioned before, the solution is integration. Really leverage any other cybersecurity audit that your company might already be doing, and leverage it as best as you can to minimize the burden of complying with this audit regulation. ISO 27001 maps very well to these requirements, those 18 requirements that we mentioned before. So you may be able to leverage that, especially in the years where you have an independent auditor doing these audits, and leverage that same audit to be able to demonstrate compliance. Last slide on what are the next steps. Step 1 is to understand that does your business need to comply? Are they in scope for these CCPA cyber audit regulations? And if they are, then making sure that you have the audit function engaged, especially for the readiness assessment, assess whether you have some recurring audits or some internal assessments that can be used as a launch pad for jump-starting this process with minimal disruption. If there's nothing in place, make sure you do a readiness assessment and start within the first 6 months, because if there are control gaps, you will need that time to be able to fix those gaps. And the last one is making sure that if you have any deficiencies, you are evaluating controls, compensating controls, have a justification that you can stand behind, that the legal team as well as the privacy and security team are okay with, to be able to represent that in the final audit report. And that's all we had. Like, Paul, do you want to come up for fielding any questions? I think we did well on time. Go
Hi.
ahead.
Are
Do you want to
these-
state your name?
I'm Tom.
Hi, Tom.
Are these audits going to be publicly available?
No, as far as the draft says, right?
That's correct. They are not supposed to be made publicly available. It will, they're not going to be publicly available. At least, like that's the current.
A follow-up to that is, can the California Public Records Act, which is like the Freedom of Information Act, be used to get access to these audits?
I don't think that would be the case, no.
Okay, thank you.
Hi, I'm Antonella Comiato. The question is, does the CCPA audit requirements also include employees? Because I thought CCPA also had a part for employees, protection of PII data.
It's very likely that it would be the case, yes. That for the audit, you would have to cover the entire organization, and therefore employee data, the personal information relating to employees would likely also be in scope. For organizations that are in scope. But then if you're not in scope of, that was the previous slide, if you're not in scope, then it's unlikely that you would have to do the audit.
Okay, thank you.
Hi, my name's Scott. Actually, following up on that question a little bit, this exact flow chart.
Yeah.
So where you're specifying relative to revenue or records, is that revenue within the state of California, or is that in all geographies, and you have employees or operations in California?
For the numbers here in relation to the number of individuals impacted, that would be California residents.
Okay.
But then, once you are impacted, then it's going to be quite difficult, I think, for organizations to separate, like Nandita mentioned earlier, to separate personal information of California residents and other other residents. So it may mean that many organizations may when they do their audit, they're going to be covering much bigger scope and cover all of the U.S. operations as a result.
Actually, Paul, the number of individuals is definitely based like California
yeah, yeah.
residents, but like for the dollar amount, like the 25 million, is that global revenue or California revenue?
That's a question which often comes up, and there hasn't really been any clear indication in relation to the gross revenue, because nobody's able to say, well, this is the gross revenue for California as opposed to to the U.S. and therefore it's very likely in that case that unless you are able to come up with hard figures and say, well, this is actually how much we're making in California. In most cases, it would actually be the revenue that you can show for the U.S. because for many organizations, they're not able to make that distinction.
So is this a situation where the case law just doesn't exist yet to define gross revenue and the geographical constraints on that?
Sorry, could you repeat the question?
So is it just that there is a lack of case law determining if gross revenue applies to only California or generally, like globally?
In relation to the current CCPA, there hasn't been any official, there hasn't been any enforcement action or anything which would provide us, with specific guidance. And for the regulations, they are just drafts, so they haven't.
Okay.
There hasn't been anything yet.
Cool. Thank you.
If you're dealing with personal information that a partner or a vendor's holding for you, how does the auditing work in that scenario? Do you have to audit them? Do they provide you audit results that you then provide back?
If you're working with vendors or as other data protection laws, we call it sub-processors, you would need to audit those or at least get information in relation to what are the security measures, what do they have in place, do they have any cybersecurity certifications, are they able to provide those to you? If they conduct pen tests, can they provide the results and so forth? So you would have you still need to flow down in a way those obligations on you to those vendors so that you don't have this giant gap whereby you have quite a number of security measures, but actually your vendors have very lax cybersecurity.
So, vendor management is one of those like 18 areas that you are supposed to have controls in place. And like one of the, it's like very, in like really tiny font at the bottom, like at the same slide. That's okay. But basically, this may require like that. This like vague language in there for service providers, and so this one. So it just says that they may need to help with cybersecurity audits. So service provider and contractor contracts with impacted businesses may require them to assist the business in completing the cybersecurity. So this is very high level language. We don't know what this would mean.
So we're still waiting on clarification from them on that. Okay.
We're still waiting for we're still waiting for clarification, but at the same time, like I said, if you have a big gap, that's not something that the authorities are going to let fly. So you would still need to be able to demonstrate that you have done some due diligence on the security of those vendors.
Good point.
Hi, my name's Alexandra. I had a question for the personal information for children. Are school districts impacted by this regulation?
This is
Personal information of children.
50,000 children.
What is that? I'm not sure what the definition of business is in.
Yeah, that's something to. I'm not sure on that. I haven't looked into that question,
Okay.
so I'm not sure. I guess the question is, is the school district, is it considered a business under the current text of the CCPA? If it is, then it will likely be covered. If it is not, then it's unlikely. The question hasn't come up for me. That's why I haven't looked into that.
Okay, thank you.
So
under CCPA, typically, they include, business contact information as personal information.
Yes.
Right? So can you just provide a little bit of guidance on that, how that would be handled in this case, right? Like, if you conduct business with another company and they email you, now you have their personal information because you have their email. So I guess I'm a little confused about how, this kind of plays into that, it's in terms of how would you audit that? And that's something that I've always struggled with.
So in relation to the categories of personal information, like you mentioned, it's extremely broad. It's a bit like in the EU, the GDPR, where everything is relating or to an individual will be captured. You mentioned emails and so forth, definitely, and it does mean that in relation to emails, for example, you will need to be able to demonstrate, are there access controls in place? What measures do you have to protect the emails? Because if there isn't anything in place, then it's going to be a problem. There hasn't been any official guidance as to what to do in relation to specific systems and so forth in place. But then it's very likely that they're going to take a holistic approach and to just see, what do you have in place within the organization, and are there any systems which are out of scope, and if that's the case, why? Why aren't there any security measures in place? They're not necessarily going to be checking, from a technical perspective, what could you have done and so forth. But then they would expect that you have what is common within the industry to protect the data.
So I guess a follow-up. So have you seen any type of enforcement action? So maybe I would see it when actual PII is breached, but have you seen any type of enforcement when, a database of personal business contact or business contact information, the company they work at, their corporate email address, have you seen any enforcement action when that type of information has been released?
So you're saying if there is a data leak in relation to not important, or sensitive personal information, so not, driver's license or security numbers,
so like if
but
you
just
look at a
email address and.
Salesforce CRM, right? If something like that got breached, it's all business contact information. Have we seen any enforcement action over something like that?
In the U.S., no. However, I would say that from an EU perspective, there has been some scrutiny in this respect, but it really depends on the type of data, because how many, for example, email addresses can you demonstrate that it's purely professional email addresses, or may there be some personal email addresses, for example, the personal email address of the CEO and so forth. In those cases, it could potentially raise issues, and then the volume of the data as well, right? Because if you have a huge database of 40 million individuals whose data is being leaked, the email addresses, the names, the phone numbers, and so forth, even though it's just contact details, that is definitely going to raise some eyebrows from a from a regulatory perspective. So it's the volume of the data which would also have an impact, I would say.
So my question relates primarily to the scoping issue.
Yep.
From the financial services industry, the majority of our data is GLBA covered.
Mm-hmm.
And then, the portion that's not,
Yep.
whatever fraction is California residents. And so we debate internally all the time whether we apply it only to the California residents or everybody. But for the GLBA data, there's still the private right of action to sue if there's a breach on that data. So should we be applying this? Are we going to be judged under the CCPA data security standards or the GLBA data security standards? Or should we be applying it to everything? How do we decide? Should we segment or just encompass everything?
Yeah, so you do have to make a distinction, because the text of the California law does say that it applies, but then you have to be mindful of exceptions, and GLBA is one of the exceptions. So in relation to data which is covered by a federal law, then the California rules will not specifically apply. But then there's always going to be situations where some data maybe out of scope of federal law, in which case California law is likely to apply in relation to that data. So you would have to to assess whether you are in scope in relation to those numbers and so forth, and determine whether or not you are subject to both the the GLBA and the CCPA and its regulations.
Awesome. Thanks, everyone.
Yep. Thank you very much.
Thank you, everyone. Thanks.